We're going to start out with, of course, bill introductions from committee. Seeing no bill introductions from committee, bill introductions from the audience. No bill introductions from the audience. Committee, I'm going to have my IT person advise us who's on the WebEx. So Connie can get them down.
We got Daryl Atterbury, Jay Hall, Jeffrey Easter, Jordan Mahallahan, Kenny Kitus, Mike Heim, Michelle Segan, Paul Schiffel-like, Eric Smith, Sam McRoberts, Scott Marsh.
Thank you. Got that, Connie? Thank you. First item up is House Bill 2025. Matt, are you on?
You're stuck with me today, Mr. Chairman. Mike Heim.
Okay, Mike, will you give us an overview of House Bill 2025? Sure.
The bill provides that no employee of the Kansas Department of Wildlife and Parks that's authorized to enforce the laws of the state of Kansas or a county weed supervisor shall conduct surveillance on private property unless authorized pursuant to a search warrant that is issued under KSA 22-2502. That criminal procedure statute basically requires that you have a probable cause and you have a oath or affirmation about the facts of the situation that there is a crime either being committed or about to be committed or whatever. It provides that the warrant would be issued under that statute or the Constitution of the United States. I'm not real clear what that little phrase means, or a judicially recognized exception to search warrants. And that would be the one that comes to mind as some type of exigent circumstance. The bill defines surveillance means any either physical or electronic presence on private property, including the use of installation of a tracking device. And a tracking device is defined in the statute dealing with probable cause. And it is defined to mean an electronic or mechanical device that permits a person to remotely determine or track the position or movement of a person or object, includes a device that stores geographic data for subsequent access or analysis, and a device that allows for real-time monitoring of movement. Section 2 provides no law enforcement agency of the state shall enter into an agreement, whether formal or informal, with the owner or operator of a utility pole to install or have installed a tracking device to conduct surveillance unless there's a search warrant. If you've got questions, I'll be glad to answer them. You've got a full slate of conferees, and I think you're going to find out a lot about this issue in a few minutes.
Thank you, Mike. One question from Representative Heiberger.
Thank you, Mr. Chair. Thank you for being here, Mr. Heim. I just have a question about the definition of surveillance in both sections. In your opinion, does that include surveillance, electronic surveillance conducted with a device located off the property in question, or does that include only monitoring with an electronic device that's located, where the device itself is located on the property?
The bill says on private property. I think I think maybe it is intended to include more than just surveillance on the property itself, but I'll let the sponsors of the bill talk about that. I think if it's intended to cover surveillance that include of the property off the property itself, maybe it needs a clarification amendment.
Thank you. Further questions of the reviser? Yes, Representative Reisman.
Thank you, Mr. Chairman. In Section 1, it mentions the Kansas Department of Wildlife, Parks, and Tourism, but in Section 2, it mentions no law enforcement agency. Why is it switching from a particular organization to the entire law enforcement throughout the state?
I'm going to let the sponsors of the bill answer that question. I'm not clear. I didn't draft the bill, so I'm not sure what the thinking was, except that it's a broader coverage than just Section 1, definitely.
Thank you. Further questions of the reviser? Seeing none, thank you, Mike. Proponents are listed. I will take up first Senator Carolyn Tyson. Senator Tyson. Good morning and welcome to Federal and State Affairs.
Good morning, Mr. Chairman. I think Representative Corbett will do more justice to the bill, but I'll kick us off.
I just have you listed. If you want to let Representative Corbett go first, it'll be fine with me.
I think he would do more justice to the bill. I'm going to rant and rave over freedom. And
Okay.
okay, thank you.
Representative Corbett. Good morning, sir.
House Bill 2025 would prohibit Kansas Wildlife and Parks and the weed supervisors from kind of coming onto your property without a search warrant. This bill is not to deter or hurt anyone who's trying to do bad things, but it just simply it gives the landowners of this state the opportunity to kind of be protected with the Fourth Amendment. I think Kansans have a right to know who's coming on their property and when. I think it's a good bill, and the surveillance, the packet that I gave you kind of tells some stories about that. But it's not to prevent anything with law enforcement. The only two agencies listed here is Kansas Wildlife and Parks and the county supervisors. So I'll take some questions. Anybody have any questions? Yes, sir.
Yes, thank you. You'll stand for questions. Chair has one. We have a statute for the weed departments that they are required to do an annual inspection for noxious weeds. How do they accomplish that obligation? Because with this, I understand they would require to go to the district court and get a judge of competent jurisdiction to issue a warrant based upon probable cause.
Probably the simplest thing to do with any of these situations would just call the landowner and say, Mr. Corbett, we're coming by your place today. We'd like to see if you've got any weeds. And 99% of the time, the landowner will probably say, just come by the house and we'll go take a look at them with you. That's the way it's going to mostly happen. This is for the times that, in this day and age, you see people out in the middle of your farm. This is not just a rural issue for wildlife and parks. They can actually come to your house in the city, check your freezer, whatever they want to do. But most of the time on the noxious weed problem, the farmer and the department probably know each other. They probably buy chemicals from each other. And it's just like whether it's a dam inspection or anything like that, they just make a phone call. It would probably just work out.
Okay, thank you. I have a question back here for Representative Penn.
Thank you, Mr. Chairman. Thank you, Representative, for bringing the bill. I'm out of Wichita, and I have a letter here from our sheriff. And thanks to the efforts of Ms. Connie to get us the opposition testimony, we get to see that there's a few things. We're looking at the crime rates and spikes that we see down in our area. This Section 2 talks about the tracking device, and I would imagine that it extends over law enforcement operations as well. What are your thoughts? Would you be amenable to only having this apply to the county weed officials as well as the Parks and Wildlife, and exclude the Sheriff's Department and Leo?
That would be considered probably a friendly amendment.
Thank you so much, Mr. Chairman.
Further, Representative Heiberger. Thank
you, Mr. Chair. Representative Corbett, thanks for being here today. It kind of scares me to find myself largely in agreement with you. Is this bill intended to, I'm going back to the same question I asked the revisor, is it intended to cover surveillance of property by a device placed off the property, or just on devices installed on the property itself?
Some of the phone calls I've had have been, if the cameras or surveillance wasn't on the property, it may be on if you're in the county, maybe a light pole on your neighbor's property pointing at your property.
And is this bill intended to cover that?
Yeah, and I think, I don't understand why anybody would be so excited that you'd want to be surveilled upon without your permission. I think there's enough of Big Brother circling this country right now. I think it gives everybody a little more freedom.
Thank you. Representative Howe.
Thank you, Mr. Chairman. Thank you, Representative Corbett, for your testimony today. When you're talking about surveillance, are you specifically talking about video surveillance? And if so, what are they surveilling for? Because if it's noxious weeds, are they looking to see if weeds grow, or can you explain a little bit more about that?
This is probably more directed towards the non-weed part of this testimony. But I just think if you're a Kansas resident, you should have the right to know if they put a GPS tracking device on your vehicle or whatever they're trying to do. The surveillance is a big thing right now, but this bill kind of takes care of that. Whether it's the noxious weed won't be part of the deal, probably. But you know, some of the landowners have game cameras, and what I'm trying to do, another part of this is, a lot of times in a rural area, people are hunting or shooting their guns or doing something. And if you don't know who's out there, this could stop somebody from actually getting hurt. So that's one side of this.
That raises one question. Are you telling me that either law enforcement are putting tracking devices on vehicles without authorization from the court?
I can't tell you whether they're doing that here, because what you will never know. But in your handout from the state of Tennessee, it was pretty evident what they were doing. And I just think that this would kind of put a stopgap, maybe not a roadblock, but maybe a caution sign to say, hey, Kansans need a little protection. We're not working against you. Just give us a call, and we'll try to get it worked out. But I wouldn't want somebody from Wildlife and Parks coming down through my barn area 2 in the morning, and my alarms are going off, and I don't know if he's a bad guy or a good guy.
Okay, understand. Further questions? Yes. Go ahead.
Thank you, Mr. Chairman. Representative, I think one of the things that are going to be very complicated in this, especially if what you're trying to do is just delineate for 2 organizations or 2 entities. As a rural deputy sheriff, I enforce Chapter 32 laws as well. So is it going to say that I can't enforce those in the same way that I do other laws because I'm coming over onto what you would consider wildlife laws, or how would that be discerned?
I think that Representative's his question, this excludes what you are. You'll be just like you always are. Sheriffs, law enforcement, if that amendment would be on, you just live your life as normal.
you. Further questions of the representative? Yes, Representative Potter.
Thank you, Mr. Chairman. Representative, it's my understanding that this bill came about because you had constituents who found surveillance on their property. I wondered if you could expand on that issue.
It wasn't not on my property, but I had calls from landowners in Anderson County and Osage County, and they brought it to my attention. Then I started searching the internet and saw that in some states it's even a bigger problem. This is just kind of an early stopgap, so the people here will be protected just a little more.
Thank you. Further questions of the conferee? Yes, Representative Reese.
Thank you, Mr. Chairman. Representative, is there a chance that stumbling on somebody's property that we have illegal marijuana patches growing, on people's farms? Is that a possibility?
Where's your farm at?
Kansas.
Yeah. This bill won't have any effect, I don't think, on that. I think basically a phone call, and if somebody is doing something illegal, and whether it's law enforcement or wildlife and parks or the weed department know it, and it's a big deal, and the landowner won't participate freely, then just get a search warrant, go in there and make the bust, make the arrest, take care of the bad guys.
Thank you. Representative Hauser.
Thank you, Mr. Chair. Thank you, Mr. Corbett, being here. Your bill's not going to ban the surveillance of any kind. It's just they have to have a warrant for this, right?
That's right. You can do all the surveillance you want. I just think the people that are being surveilled upon should know what's happening.
Thank you, Mr. Chair.
Thank you. Further questions of the conferee? Being none. Thank you, sir. If you'll.
Chairman, committee.
Next up, Senator Tyson. Good morning again, and welcome to Federal and State Affairs.
Good morning, Mr. Chairman, and thank you for allowing me to testify. Good morning to the Vice Chair and the Ranking and all the committee members. This is such an important bill. Our founding fathers, they were about property rights. We know it. It's in our Constitution. It's in the laws. And not only were they about the right for being able to sell and purchase property, they were about the right of restriction, of who has access to our land, and that's what this bill does. It's a sad day in America that we have to write legislation and laws to restrict who can come on our property. We should be able to do that by default, but here we are today, instead, defending our rights as property owners. I ask that you support this bill. I've got a couple of quotes in my testimony, but one of them that I think is so important. A man is said to have the right to his property. He may be equally said to have a property in his rights. Where an excess of powers prevails, property of no sort is duly respected. No man is safe in his opinion, his person, his facilities, or his possessions. We must protect these freedoms. We're protecting our freedom of speech in current times. This is unprecedented. So I ask that you stand and support this bill and the fact that property owners should have the right to know who's on their property and for what reason. I'll stand for questions.
Thank you. Questions of the senator? Seeing no questions, thank you for appearing here today.
Thank you. Thank you, Mr. Chairman.
My next conferee is Samuel McRoberts, Kansas Justice Institute by WebEx.
Good morning. Thank you for having me. My name is Sam McRoberts. I am the litigation director at Kansas Justice Institute. We're part of Kansas Policy Institute. I wrote some testimony about the Fourth Amendment and Kansas Constitution Section 15, which is the functional equivalent of the Fourth Amendment. It protects against warrantless searches and seizures. I think it's incredible we're having this discussion today. I'm excited that we're having this discussion. I think it's important to have these discussions. I hope I didn't bore everyone with my Fourth Amendment analysis, but I think it's really important to this issue. I think this bill is a really straightforward bill that helps restore privacy and property protections for Kansas. And as one of the representatives stated, this doesn't mean that conservation officers can't conduct surveillance. It just means that they need to get a warrant. And I think that that is completely appropriate. And it's really the whole purpose of the Fourth Amendment. It's the whole purpose of Section 15 of the Kansas Constitution. And I think it's also correct when Representative Corbett said, just ask the property owner for consent or permission. And I agree that I strongly suspect Kansans would allow a conservation officer to walk around the property, and I don't think that's going to be a problem. At the end of the day, I do think this is a very reasonable bill. It's appropriate, and it helps restore property rights and privacy rights of Kansans. And I'm happy to stand for questions. In my written testimony, I talked about the open fields doctrine, which is exactly at issue in the Tennessee case that Representative Corbett mentioned. And that's one of the issues that is going on. And the reason it is an issue is because the United States Supreme Court has created either however you view it, it's either an exception to the warrant clause or it states that it's not considered a search in open fields. And so that would presumably give the authority to officers to go onto a person's private property. And so this is just a way to essentially close up that loophole to the Fourth Amendment or to the Kansas Constitution, Section 15. So at the end of the day, this is just about restoring property rights and privacy rights for Kansans. Thank you. And I'm happy to answer any questions.
Thank you. Representative Heiberger.
Thank you, Mr. Chair. In your opinion, would the U.S. Constitution or the Kansas Constitution require a search warrant for placing an electronic surveillance device on a location off the property to surveil the property in question?
Great question. I could probably talk to you about that for hours on end. The United States Supreme Court is dealing with electronic surveillance. They've dealt with it first in the context a while ago with thermal imaging cameras that were pointed towards people's homes. Then they're dealing with it in terms of, can law enforcement officers search a cell phone? Then they started dealing with records being available through off-site, basically cell phone antennas. And so the Supreme Court's dealing with this right now, this precise issue. I can't really hazard a guess on what they're going to say about this, but the part of my analysis in that letter is we're dealing with two different things here. We're dealing with a person's right to privacy, which is the Katz test under the Supreme Court, and we're dealing with a person's protected property interest, which is a Jones-Jardines test. And so without boring everyone here, right now the Supreme Court is kind of grappling with these two types of issues. And so if a person does not necessarily have a reasonable expectation of privacy, they still might have a Jones-Jardines expectation to require a warrant. So it's two kind of separate things that are going on right now. And the Kansas Supreme Court they interpret our Section 15 in lockstep with the Fourth Amendment from the United States Supreme Court. So I don't know what the Kansas Supreme Court's going to do, because essentially they tend to wait on what the United States Supreme Court says on these issues.
No further questions? Great. Yes, Representative Howe. Oh, I'm sorry. Let me go to Hauser first, and then you. Go ahead, Representative Hauser.
Thank you, Mr. Chairman. My question is, say they have I'm pretty ignorant on the laws. I've never been under surveillance or anything like that before. Let's say yet, knock on wood. Let's just say that they do have a warrant to surveil my property. So I do not have to know, I mean, they don't have to inform you that they are doing it, right? required, if they have a warrant to do so, and you like say, hey, what's that camera doing over on that pole over there? Do they have to disclose to you that that is their camera and they are surveilling you?
So I think that the Kansas statutory requirement for warrants will outline what needs to be disclosed to the person and when it needs to be disclosed. And so my recollection is that's going to be contained within the statutory scheme.
Okay, thank you. Thank you, Mr. Chair.
Representative Howe?
Thank you, Mr. Chairman. Thank you, Mr. McRoberts, for being here. My question deals with your interpretation of this proposed legislation. Would this also affect satellite surveillance or unmanned aerial vehicles?
That is a fantastic question, and that really goes to the heart of this open fields doctrine case. And there are Supreme Court cases that discuss whether or not you have a reasonable expectation of privacy in things taken from up above. And so there are cases dealing with this. So the short answer is it implicates these things. And so that's why we should have this conversation. But the way that I view the bill as it's written, this is more dealing with the open fields case that was in Tennessee. That's my impression of things. And so what this bill is attempting to do is to keep officers from going onto a person's private property to look for poachers, or it's dealing with them setting up cameras to look for poachers without the property owner's permission. And so I think that's really more what this bill is designed for, as opposed to drone surveillance. But it's a really good question, because there are cases dealing with aerial surveillance. And so, and it goes to the heart of the question, do you have a reasonable expectation of privacy in your property, or what you're doing on your property, if there's a drone flying above your property?
Thank you, Mr. Chair. I know that in my community, there are cameras installed on traffic lights. The traffic engineers use those to help direct traffic in the case of accidents. And I know that law enforcement does have access to that footage as well. My concern is that the way this is written could require them to have a warrant for these cameras. Is that the intent of the bill?
I would direct that question to Senator Corbett. Did you get the question?
The intent of the bill has nothing really to do with traffic lights and whatever. This is more to deal with private property and surveillance thereof of these means. Has nothing to do with running lights like your cameras you're talking about.
Miller.
For Mr. McRoberts, Mr. Chairman. Mr. McRoberts, you mentioned the right to privacy. Isn't it true that the U.S. Constitution, the U.S. Bill of Rights do not explicitly include a right to privacy, but that was simply something created by liberal justices of the court, making laws of their own?
I appreciate that question very much, and I guess I would not characterize justices as either being liberal or conservative. That's not really my interest. I'm not inclined to affix that label on people, especially the courts. But you're correct.
Isn't it true that the right to privacy was created by the Supreme Court in Griswold versus Connecticut?
I think it's fair to say that
A case, not a section of the Constitution.
I think you are correct that there is no explicit textual right to privacy.
So we would just
rather than liberal or conservative, we would just call them activist judges.
Well, that's a great conversation. I'm always happy to have that conversation. I don't like the term activist judges. I think it's in some ways very silly to call judges activist judges, and I believe that. I think it's silly to ascribe that to judges.
Right, then I apologize. Thank you, Mr. Chairman.
Thank you, Senator. Further questions of the conferee? Seeing none, Mr. McRoberts, thank you for coming or appearing here today by WebEx.
Thank you.
Committee, we have some written proponents. John Donnelly, Kansas Farm Bureau. Testimony is in your file. Kendall Seal with the ACLU of Kansas, also as a proponent. Now going to take up anyone else appearing as a proponent that's in the audience. Seeing none, I will close that portion of the bill, and I will open up the opponents. First up will be Greg Kaiser, Kansas Department of Wildlife and Parks and Tourism. Good morning, sir. And welcome to Federal and State Affairs.
Good morning, Mr. Chairman and committee members. I'm Greg Kaiser. I'm the Law Enforcement Director for Kansas Department of Wildlife and Parks. I'm here to speak on behalf of the certified law enforcement officers with the Public Lands and Parks Division, as well as the Moan Division. A little bit about myself. I come from a law enforcement family. My grandfather was a game warden here in Kansas. I became a deputy sheriff in Southeast Kansas, later became a state trooper and retired after 30 years with the rank of captain over the aircraft unit here in Topeka. After setting out a while, I was able to follow my grandfather's footsteps and became a game warden. We believe House Bill 2025 is not needed. It would have many negative consequences as we seek to protect people, property, and wildlife here in the state of Kansas. In talking with our staff, we've been made not aware of any complaints about misuse of our authority. I have specific recent examples in which House Bill 2025 would have inhibited our abilities to do our jobs. We work side by side with law enforcement agencies across the state, local and state. Many times they depend on us, we depend on them. Myself, not having always been a game warden, I worked the road for many years. There was many times that I was in a rural, not only here in Topeka, but in rural Kansas, where it was very important to have backup. Many times that was the game warden that showed up because he knew where I was at. I had one incident at my residence where I didn't call my fellow troopers or deputies. I called the game warden. He knew how to find me. Personal experience, especially with aircraft, we were called out on a regular basis to look for missing and lost people, people with dementia, elderly, and time is of the essence. Especially when nightfall. I have a few examples. I have pages of examples. There's only a few I'm going to share with you. Several years ago at Cedar Bluff State Park, we had a 911 call about an individual that had taken someone hostage. Our park staff responded, searching all farmhouses in the area. They found a lady tied up in a barn, suspect in a nearby house. They took the man into custody. The lady was okay. February 2020, Swiftwater Rescue in Butler County. The Rangers access private lands on both sides of the river to deliver life jackets and ropes to a woman trapped in the water. If we would not have been able to access private land to help her, we would not have been able to effect that rescue. In 2020, in June of 2020, an aggravated assault, we had Rangers respond to a private residence in Butler County to assist Butler County Sheriff. Call was for a man with a gun threatening a family member. Ranger and the game warden were first on the scene. The Ranger contacted the suspect and was able to determine that he no longer had a gun, and the deputies arrived and finished the case. In Jackson County, 2016, we had a 4-year-old girl let herself out of the house while her mom was sleeping. Temperatures were near 100 degrees as a warden and his canine tracked the girl for over a mile. A second canine from our agency was used to finish the track, and the girl was found alive but extremely dehydrated and very unresponsive. It's likely she would not have survived if she had not been located in a timely manner, and that was all on private property. We would not have been able to go on if House Bill 2025 was in effect. Buncey County in 2015. At a canine that was called to locate a young boy who had ran away from his grandmother at a rest stop at I-70. The boy was suffering from a disorder where he was obsessed with water. It's called Angelman syndrome. The canine tracked the boy across I-70, and he was located nude in the creek under a log on private property. This was March, and the boy was hypothermic. Just a little bit over 2 weeks ago, a Wildlife and Parks game warden with a drone was called to locate a 74-year-old woman with dementia who had walked away from her rural Morris County home. The game warden deployed the drone in search of the woman, who was found before dark. She had laid down between 2 rows of brown hay bales to stay warm after she had grown tired. These are just a few examples that I've got 3 pages worth, and these were just from yesterday on short notice. There's many more that are out there. House Bill 2025 would have taken away our ability to search from the air for missing persons or to observe people spotlighting deer. As a former commander of the aircraft unit, I was on many poacher flights as either pilot in command or as a co-pilot. Every one of those flights there was a game warden on board. That was to coordinate efforts on the ground. This bill would eliminate the game warden being able to go on those flights. However, the troopers would still be able to do it. It would interfere with our ability to consistently back up fellow officers on private property when the need arises, which jeopardizes officer safety. And lastly, Statute 32-1013, passed in 1971, allows for landowners and ranchers to paint their fence posts purple. That eliminates the need to put out written permission signs every year. This is a program that is a landowner benefit and enables us to check hunters as we see on their property for permission slips and prosecute them without the landowner involvement. This is a very popular service that we perform, which would be disabled by House Bill 2025. I will touch on a couple other things that was in previous testimony. Trackers. We have used trackers in the past. Everyone have been under the direction of a search warrant. We never put a tracker on anything without a search warrant. The curtilage issue, searching barns, that requires a search warrant. We would not go on people's property to search houses or barns. There's a misconception about that. Since becoming a game warden, I've had people ask me, how do you like being a game warden as opposed to a trooper, because you have more powers now, which has shocked me because that's inaccurate. I don't have any more powers now than I had when I was a state trooper. I can't go in your house and search your freezer without a search warrant. A lot of people think that's the case. That's not true. We are the same as any other law enforcement officer. We have to go by the same rules. Also, there's been talk of previous testimony about constituents in Anderson County having concerns about wildlife parks placing cameras on their properties. I will tell you that I was the Anderson County Game Warden for 2 years. Since I left, that position is vacant. During that 2-year period, I put 1 camera out. That was at the request of the city of Garnett on their golf course because an animal was tearing up the sand track. That's it. There have only been one instance that, well, there's been no instance of us using cameras on private property. I polled our whole staff in recent years. Nobody could think of any one instance. There was an instance back in 13 years ago where a camera was placed in rural Barber County in south central Kansas. That was for a commercialization poaching case that ran from 2005 to 2008. Involved 30 individuals coming from out of state guiding. In the end, with cooperation between our agency, U.S. Fish and Wildlife Service, and the Texas Fish and Game, 30 individuals charged. 119 deer, trophy deer, were seized that came from Kansas. It resulted in 5,000 man-hours worth, 5,000 pages of reports.
I'm going to have to ask you to wrap it up. I've got 6 other conferees.
That was one of the largest cases in U.S. history. And I will take any questions.
Thank you. I have a list of questions. First up, Representative Heiberger.
Thank you, Mr. Chair, and thank you for being here. And I just want to go back to some of your testimony. You talked about, I appreciate the fact that you were involved in all the rescues that you talked about, but the statute itself, in the bill itself, it prohibits surveillance without a warrant, and it defines surveillance. I won't read the whole thing, but it includes to monitor activity or collect information related to the enforcement of the laws of the state of Kansas. So would any of those rescues that you described be prohibited by the language of the statute?
We feel that it would. Surveillance, I've been on surveillance where we're looking for a man and driving down the road looking on the property to look for somebody. I think the big concern is when we go on private property at all without a warrant. What is the definition of surveillance?
Thank you.
Thank you. Representative Armberger.
Thank you, Mr. Chair. Now that you've had a chance to listen to the proponents and see the intent behind the bill, do you agree with the intent and maybe disagree that it is not written to your liking, or are you 110% against the intent behind the bill?
We oppose the bill at this point because we believe it's not needed. There's not an issue with wildlife parks going on people's property, throwing cameras.
Okay, thank you.
Thank you. I'm going to go to you, Representative Miller, and then I'll have a question.
Thank you, Mr. Chairman. Thank you, sir, for all your years of service in all those capacities. I appreciate it. Tracking back to the question by Representative Heiberger, I think the relevant language is on lines 11 and 12 of page 1, which provides an exception for, it reads, any judicially recognized exception to the search warrant requirement. And without getting into a long discussion of it, I'll leave it to the lawyers that know more than I do, but there's things like probable cause and hot pursuit and
circumstances,
felony offenses, and we don't have his written testimony. I would like to get that list that he went through, because I think every one of those would fall in clearly a category that is currently an exception to having a warrant. And there are numerous exceptions, which, for good reason, that's why we have them. And his list, I think, hit on just a whole bundle of those very exceptions, and this bill would not apply to any of those circumstances. Thank you, Mr. Chairman.
Thank you. I don't know if you keep data on this or not. How many, do you have the information of how many times Fish and Game has applied for a search warrant on a property in the last year or two or anything? Do you keep that data?
I don't have that data in front of me, sir.
Okay, thank you. No further questions of the conferee. We're going to take the next one up and move a little quicker. We've got a number of them to take up. Thank you for coming here today. Alan Hollinger, Noxious Weed Director, Douglas County Public Works. Good morning, sir. Because of our time restraints, I'm going to have to limit you to about 4 or 5 minutes.
Yes, sir. Thank you. Good morning, Chairman, committee members. Excuse me if I get sidetracked a little bit. I'm a little nervous. This is the first time I've done this. I do want to point out that in the Kansas Noxious Weed Law, as it is already written, Chapter 2, Article 1316 requires noxious weed directors to reasonably notify a landowner for our weed surveys, which we do twice a year, and any enforcement action, meaning phone calls, in-person meetings, registered letters, emails. So as the Noxious Weed Directors Association, we don't feel that there's a need for an additional level that we need to go through, being in our weed law, we are already taking these steps. Also, if you're familiar with noxious weeds, especially the musk thistle, if a landowner has a complaint about a neighbor or whatnot, and things are going to seed, you've got a matter of a day or two to try to make contact with that landowner anyway. So with that being said, I will answer whatever questions the committee may have.
Okay. Questions for this conferee? So you're indicating that in statute presently you're required to contact the landowner first.
Yes. And additionally, we don't survey anything, surveil anything. But yes, Chapter 2, Article 1330 requires us to make reasonable attempts to notify landowners before we enter property. Phone calls, in-person, email, certified letters.
Now, if you find that you can't contact the landowner and you go on, do you later notify them that you have been on their property?
Well, I will only speak for myself because I am part of public works, so I have multiple layers of people I have to go through. If I can't reach a landowner, I will not enter that landowner. I will find a neighbor that can maybe take me up, and I can look across the fence and say, yes, they have a problem.
Thank you. Based on my inquiry, Representative Heiberger.
Thank you, Mr. Chair. If there was a clear exception for noxious weed inspections in the statute, would you oppose it?
No, we would be neutral.
Thank you.
Thank you. No further questions? Oh, Representative Howe.
Thank you, Mr. Chairman. My question has to do, how do you approach dealing with absentee landowners? We see more and more land being owned by out-of-state landowners. How do you deal with that?
Well, again, we do everything we can. You know, I'll go down to the Register of Deeds, try to find out who the landowner is, get a current address. I can give an example of one in Douglas County that is an absentee landowner that we have entered 3 times. I just send certified letters. If I don't get them back, I assume he has received the letter.
I'd suggest you contact ACS. They send them the check, and I'm sure they cash their check from the Department of Agriculture, but that's just a comment I made. Thank you, sir. Oh, we have Representative Miller.
Yes, very quickly, Mr. Chairman. I'm not sure what the objection is because the testimony was they don't conduct surveillance, and what the statute clearly prohibits is surveillance. So I don't see the issue. If they don't surveil, why do they object to not being able to surveil? That's my question.
Thank you. That's not for you. That's just for the committee. Next up is John Goodyear, League of Kansas Municipalities. Good morning, sir, and welcome to Federal and State Affairs.
Mr. Chairman, and good morning. My name is John Goodyear, and I'm a staff attorney with the League of Kansas Municipalities. I just want to start my testimony today by thanking you, Mr. Chairman, and the members of the committee for affording me the opportunity to give testimony today in opposition to House Bill 2025. Now, Section 1 of this bill doesn't apply to our member cities, so my testimony doesn't speak to Section 1 of the bill. Instead, I'll be focused on Section 2 of the bill. This section would limit the ability of all law enforcement agencies to enter into agreements with owners or operators of utility poles to install tracking devices absent a warrant. Now, in order to be granted a warrant, an agency must be able to demonstrate that probable cause that a crime has been, is being, or is about to be committed exists. And surveillance or monitoring of a property is often one of those tools that is utilized early on in an investigation in order to help build a case or help demonstrate the probable cause sufficient to obtain a warrant actually does exist. And it appears that the intent of this bill is, maybe not, but as written, it could limit the ability of law enforcement agencies across the state to use these early monitoring tactics in an effort to detect crime or establish probable cause. As written, the bill only applies to tracking devices that are put on utility poles, and tracking device is defined in statute as a device that permits a person to remotely determine or track the position or movement of a person or object. So it is a limited definition, but our fear is that the goal of this legislation is to curtail a general monitoring or a general surveillance, effectively removing a tool used by local law enforcement agencies in order to detect criminal behavior, particularly in a high traffic or a high crime area. Monitoring property is one of those tools that is necessary for law enforcement efforts to detect and prevent crimes within their jurisdiction. If further limitations are placed on this ability, it's going to be more difficult for law enforcement officers to be able to do their jobs and protect their communities, keep their communities safe. For this reason, the League opposes this bill and would request that the committee not recommend it favorably for passage. Thank you, Mr. Chairman.
Thank you. Questions for the conferee? Yes, Representative Potter.
Thank you, Mr. Chairman. And thank you for your testimony. I had a question, particularly with the utility poles versus if they're located on private property versus public property, if that was changed or amended within this to state any utility poles located on private property. Because I think that's the issue came up with a camera being placed on a utility pole that was located on private property.
So I'm sorry, I'm not sure that I understand.
Okay, so from my understanding of the intent of this was that a camera was found on a utility pole on private property. So if that utility pole was on public property, it would be no different than having a stakeout and watching from a vehicle versus this being on, if it was amended to say that any utility pole was on private property.
As written, the bill applies to any utility pole owned or operated, and the agreements that you enter into with the owner operator of the utility pole. So often in cities, like I live in the city of Lawrence, I don't believe the city of Lawrence owns those utility poles. They're owned by Evergy. So it would limit those regardless of whether or not they're actually on a private property or just out on the public property. Thank you.
Thank you. Further questions of the conferee? Seeing none. Thank you, sir.
Thank you, Mr. Chairman.
Next up, we'll have Sheriff Easter, Kansas Sheriff's Association. I think he's on WebEx. Sheriff, are you on?
I am, sir.
Please proceed with your testimony.
Thank you. Thank you to the committee for hearing us today. I've submitted written testimony. The Kansas Sheriff's Association is an opponent of this bill. There's many reasons why. First off, the bill is very confusing of what actually its intent is and what it means. Secondly, to kind of clear up some things that I've listened to here, GPS tracking devices, those are miniature devices that can be placed on vehicles. They require a search warrant to even place that on a vehicle, and that's by case law. There is no case law. In fact, the case law supports the fact that if we gain permission from a homeowner or from an owner of a utility pole, which most are on public property, that we can conduct surveillance without a search warrant. And so the fact of the matter is that we have some concerns about what is called a tracking device. First off, a tracking device, by the definition, there's no reason why we'd put a tracking device on a pole. It's stationary. It's not moving. And so we believe the intent of this is to curtail law enforcement from conducting surveillance using a pole camera on a piece of property that we've either garnered permission from a property owner or we've garnered permission from the owner of the pole. Now, with that said, to gather probable cause to get a search warrant, there is a lot of different tools that law enforcement uses, including surveillance. When we talk about surveillance, I think a lot of people are like, well, they're talking about drug houses. Yeah, that's part of it. We've utilized pole cameras for numerous types of cases, homicide cases, robbery cases, human trafficking cases, you name it, to try to establish probable cause to get a search warrant to actually search the property in question. We also get called quite often from homeowners, especially in the city, saying, hey, there's a drug house that we've had shootings at, that we've had all kinds of criminal issues, and if you want to come and put a camera or you want to come into our house to surveil this particular property, you're more than welcome to. And so when it comes to property rights, I understand completely that if law enforcement is going on to property owners' property and just searching sheds, garages, refrigerators without a warrant, that is illegal. We cannot do that. But when we start talking about limiting surveillance methods that's not on their property, but that is monitoring their property, that's another issue. And I truly believe that that's an issue the Supreme Court of Kansas or the Supreme Court of the United States should weigh in on and not legislate for. So the fact of the matter is that this will highly curtail us even getting probable cause to do a search warrant. And we have a lot of bad actors out there that will not give you permission for anything to do on their property. In fact, we won't even ask them on a homicide case if we're looking for a homicide suspect and we can do surveillance, we'll do so. The last item that I'll bring up is in the bill itself. It talks about what surveillance is, means either physical or electronic. Does this prevent us from setting down the street and observing a piece of property physically? So there is a lot of issues with this bill that we have concerns with, and I'll stand for questions. Thank you.
Representative Miller.
Thank you, Mr. Chairman. Sheriff, I'm looking at the language of the statute, and I don't see anything here that limits you on the activity you just described. And I haven't pulled up the definition of tracking device, but I think you said putting these things on poles, they're not tracking devices, right?
That's correct. A tracking device is placed on a moving object. A pole is not a moving object. It's talking about a camera.
What I read the bill as, the only time I see law enforcement mentioned, if we don't count wildlife and parks, no law enforcement agency, and it talks about the utility pole issue, and it talks about tracking devices, so it does not appear to apply to anything you do. So where in the bill does your current activity get limited?
Well, I respectfully disagree with you, sir. It says no law enforcement agency in the state shall enter into an agreement with informal or formal with an owner or operator of a utility pole to install or have installed a tracking device to conduct surveillance on private property. That's where it's confusing. Tracking devices would not be placed on a pole. A camera would.
And those are, you just said those are not tracking devices. And this prohibits tracking devices.
Well, that's what, yes, sir. That's what I'm saying. I don't know what the intent of this law is. That's the problem, is legislators believing that a tracking device, because I've heard some other people testify, that is considered to be a camera. That's what I'm opposing, is because we'd never put a tracking device on a pole, but we do put cameras on poles.
And one last question, Mr. Chairman. Have you looked at the definition of tracking device under KSA 222502? Because that's what's prohibited.
Yes, sir.
And
it's
the question would be, are the devices you're talking about covered by that definition?
Well, because it's vague in nature, sir. The interpretation from some folks is that it is, and from some folks it is not. And so I'm going with the latter, that it is.
And I don't have that pulled up, so I'll have to pull up that definition myself and see what it covers. Thank you, Mr. Chairman.
Thank you. Representative Smith?
Well, I did pull up that definition, and Sheriff, if you don't mind, I'll just read that real quick. A tracking device means an electronic or mechanical device that permits a person to remotely determine or track the position or movement of a person or object. Tracking device includes, but is not limited to, a device that stores geographic data for subsequent access or analysis, and a device that allows for the real-time monitoring of movement. So that by itself would be a GPS. The problem that I see, Sheriff, and if I could direct you back to the bill, section 2 that you just read from, and then you go to B1, the definition of surveillance. And I think that's where you're trying to describe whether by physical or mechanical means surveillance. So that's where we run into the problem. Am I correct?
That is correct, sir. And by reading the statute, you can see where there's some confusion in tracking, because yes, it appears to talk about data, analysis of data, but it also says monitoring. So some folks have determined that to be that it's a camera.
Thank you.
Thank you, Mr. Chair. Sheriff, it's great to see you twice this week. I just have a quick question now that you've had a chance to hear from the proponents. Would you state that what they stated earlier, that this is an issue? And if it is an issue, how do we make this bill a compromise?
Okay, so what I had heard was information being relayed that wildlife and animals folks were just going onto property and searching property with no permission. Again, that part, there's already remedies of that, because we shouldn't be doing that, and that means the case will never get charged. And then there should be people talking to whoever's doing that saying that's illegal. When we talk about property owners' rights, I cannot go install a camera on someone's property to surveil them without a search warrant. And so what we're really looking at here is doing surveillance off that person's property from another person's property to conduct surveillance on that property that's supposedly doing criminal in nature activities. I don't know what that compromise would be, to be real honest with you, because there's a lot of public view statutes or case law out there, or plain view type stuff. And in a lot of these investigations, you can't, first off, in these neighborhoods, they're going to know your cops. Second off, you can't sit there 24 hours a day, 7 days a week to monitor the activity. That's why we utilize cameras. And so anything to do with limiting our ability to utilize those cameras on property that's not owned by that particular person, we will be opposed to.
Thank you, sir. We're going to move on. Thank you, Sheriff, for appearing here today. We're moving on to Chief Daryl Attenberry with the Kansas Association of Chiefs of Police. He's appearing by WebEx. Chief, are you on?
Yes, I am.
Please go forward.
I would also like to concur with Kansas Sheriff's Association and Sheriff Easter that the Kansas Association of Chiefs of Police strenuously opposes House Bill 2025. We have some real concerns that this bill will interfere with the apprehension of criminals. A lot of what I have to say, Sheriff Easter has already said, but I'm going to focus more on our concerns with wildlife and parks, because they've been singled out as the one law enforcement agency in the state of Kansas to control with this bill, and that's just not right. This bill is going to severely interfere with the apprehension of poachers, people who are violating our state's animal, fish, and bird laws. It's going to put some of our natural resources in a precarious situation, because those people who find those violations, whether they be poachers or people illegally dumping materials into our waterways, those are Kansas Department of Wildlife and Parks officers. And from our perspective, the damage that can be done to our state because you restrict Kansas Department of Wildlife and Parks officers could be tremendous. An example that goes to Section 1, and it was touched on by Sheriff Easter, was our concern about the removal of the concept of plain view from the abilities of Kansas Department of Wildlife and Parks officers. And an example would be, and I put it in my written testimony, say the wildlife officer has just left a neighbor's house. He's driving down their driveway. He gets near the end. He's still on their private property, but he sees suspicious activity across the road. That is physical surveillance of plain view activity, even though it's on some other piece of property. This bill, Section 1, says that he can't do that. He's got to go get a warrant to do that. He doesn't have probable cause to get a warrant. That's what he needs. That's what a judge is going to require. He has a suspicion that something may be going on based on his experience as a law enforcement officer. So what you've done, or what this bill would do, is to put plain view activities out of the purview of a wildlife and parks officer so that they're not able to do their job as the citizens of the state of Kansas would like them to do. Because I don't believe everybody holds Mr. Colbert's impression of the Kansas Wildlife and Parks officers. They do a valuable service for our communities, our counties, and the state in general. I have to also take issue with Mr. Colbert's testimony on just give them a call. When you're talking about weeds, that's probably fine. But when we're talking about illegal grow operations, meth labs, poachers, cattle rustlers, that happens. It's not wise for us to call the criminals and let them know that we're going to be surveilling them. That's just not logical. And in the cases of weeds, okay, I'll go with that. But in many of the things that we work on in law enforcement, drug houses, chop shops, people who cut up stolen vehicles, fronts for other criminal activities, it's just simply not wise for us to call them ahead of time to let them know that we're going to be looking at them. So
wrap it up. We're going to have
okay, I'll certainly do that. So we believe that Section 1 is bad for Kansas Department of Wildlife and Parks. Section 2 is certainly bad for law enforcement in general in the state of Kansas, as outlined by Sheriff Easter. I will reiterate that we believe this is bad for law enforcement, this bill, and it's bad for the citizens of Kansas. I'll stand for questions.
Thank you, sir. Committee, I'm going to go ahead and take up the other opponent, and then we'll have questions of the last two. Deputy Chief Paul, is it Schlick, Kansas Peace Officers Association by WebEx? Are you there, Deputy Chief? Not look like he is on. I'm looking at my IT person. He is? Okay. Deputy Chief?
Yes, sir.
You can proceed with your testimony. I will have to limit you to about 4 minutes.
Yes, sir. I'll keep it short and sweet, and I apologize. The microphone works better when I unmute it. My name is Paul Schlifke. I'm the Deputy Chief of the Wamego Police Department. I'm the immediate past president of the Kansas Peace Officers Association, and I have about 40 years of law enforcement experience here in Kansas. The Kansas Peace Officers Association, KPOA, represents about 3,000 members of law enforcement officers here in Kansas from federal, state, and local agencies. And we oppose House Bill 2025. I will keep it short. As you've requested, I have submitted written testimony. A couple things I'd like to highlight on is that Kansas Department of Wildlife, Parks, and Tourism officers are state law enforcement officers. Part of their job and our job as law enforcement officers on patrol is to be observant. And in effect, the way this, and I understand the intent of the bill from listening to testimony, but the way this bill is written, it would basically cripple the ability to be going down the road, seeing something on private property, be a fish and game violation, being a vehicle backed up to an abandoned house, going by a house where there's known to be juvenile parties and alcohol and drugs supplied to juvenile that's on private property. Surveillance is a tool that is used to develop probable cause for a case, including to get a search warrant. And basically, the way the bill is written, the KPOA stance is that you're asking for a search warrant, which you can't get without probable cause. Another thing I'd like to highlight on is there are some locations, both in rural areas and in cities, where it's not practical or safe to have officers physically present. It could be because there's an open area where you can't park a vehicle without it being in sight, or a neighborhood where everybody knows everybody and knows where something's wrong. So in those situations, a camera can be useful, and having the Department of Wildlife and Parks or any law enforcement officer not being able to use a camera does not do a service to ourselves or to the public. There has been a lot of talk about personal property rights. I would say that when we put a camera up or when we surveil a property, if we surveil a property, just say, well, this doesn't look right, and we check on it. That doesn't mean that there's criminal activity afoot. But if we don't watch what's going on, if we see something that doesn't look right, we're not doing our jobs as law enforcement officers. And I would also say that we champion for the property rights of the citizens, and that is the reason that we would enforce the laws, is because I don't want this bill to turn into a us versus them, with law enforcement, including wildlife and parks officers, being us, and innocent property owners being them. That's not the purpose of us enforcing the law. We enforce the law to serve the citizens of the state of Kansas, including victims of crimes. And again, we don't.
You'll need to wrap it up.
Yes, sir. We do not put pole cams up because we're fishing. We put pole cams up or other surveillance techniques because we believe that criminal activity is taking place. Thank you for your time. The KPOA does respectfully oppose this bill. I'll stand for questions.
Thank you, folks. I'm not going to take questions at this time. I have a number of neutrals that I need that are here out of respect for their coming here today. So I'm going to move to I would first suggest you look at the written opponents: Robert Jacobs, KBI; Mike Shank, Kansas State Lodge, Fraternal Order of Police; Don Lehman, Chief of Police, Lenexa, Kansas. Anyone else as an opponent? Seeing none, close that portion of the bill. I'll open up neutrals. Aaron, Livestock Association. I'm sorry, Aaron, but I'm going to have to limit you to about 2 minutes, 2-3 minutes. We have your testimony, though.
Thank you, Mr. Chairman. I'm going to confine my remarks generally to the noxious weed law. I will say, however, there may be some reasons that you want to cut off the open fields doctrine, and I'm going to touch quickly on what that is because I think there's some confusion that entered. Many decades ago, the Supreme Court basically said that the Fourth Amendment only applies to your house and immediately surrounding area, garages, privacy fences, and that law enforcement can enter onto your generally open fields, if you will, the back quarter, 80, whatever. Now, there may be some reasons you want to curtail that, and I think some of my members would maybe appreciate that. They'd be shocked to find out that law enforcement can just come onto their land. But I want to confine this to noxious weeds. There's some issues as it applies to noxious weeds. Most of the noxious weeds, I think was alluded to a little earlier, is a civil remedy statute. It's rare for warrants to apply to civil remedy statutes. There are a few misdemeanor crimes, but they don't apply to the actual observation and control of the weeds. That is civil. And as the weed director mentioned, there's actually a statute, 1330, that requires him to notify somebody. Now, if he can't reach them, then there's ways to enter that, but generally he must do that. Why are we here? Well, there's an intersection here between privacy, but we also have laws that say we want to see, or policies, KLA policies, we want to see these things controlled because noxious weeds are noxious because they don't stay on your property. If they stayed on your property, probably wouldn't have a problem with them. So we want to see them controlled. And I think there's some concern when we start saying, well, we want the county weed directors to get a warrant. Because no offense to some are good, but generally a lot of them don't actually do what we ask them to do in statute. And so making them get a warrant would further deter them from controlling these weeds. The other thing I want to point out in the statute, I think the attempt here is to cut off the open fields doctrine. In regard to noxious weeds in particular, I don't think it does that because I think Representative Miller or maybe Representative Heiberger pointed this out. There's an exception still in the bill that allows exceptions to the U.S. already from the U.S. Constitution. Well, that's the open fields doctrine. So if you don't fix the bill, you've actually not changed this, and they can still go onto the property, control these weeds. The other thing I want to point out, even if you have to get a warrant, if I'm a weed guy, I'm driving by the road and I see a musk thistle, Sericea lesbides in your property, and I have probable cause. So this really doesn't solve it. So that's the purpose of here. I just want to raise some of these issues, kind of let you know our policy if we want to control these weeds, and hopefully this has been helpful. Thank you, Mr. Chairman.
Thank you. If you'll remain, if we have time, we'll have questions. Next up is Jay Hall, Kansas Association of Counties.
Yes, and I'm here on WebEx.
Go right ahead.
All right, I will be brief. The main things that I want to highlight have already been highlighted, but I'm here kind of supporting our county weed directors, and the main idea is just that, as has been said multiple times, they're already required under statute to reasonably attempt to notify individuals before entering the property. And there's also a section in KSA 2-1330B2 that allows the property owner to actually accompany the weed director onto their property to look for these noxious weeds. The other thing I want to highlight is that I'm not sure a weed director would even be able to get a search warrant to enter a property in order to do their annual surveys. Those surveys are required under law, and I think it would be nearly impossible to meet the probable cause standard in order to enter a property. And so because of that, I think it would be impossible to meet the statutory requirement of doing an annual survey. And for that reason, we would recommend that either the weed directors be removed from this bill, or if they're not removed from this bill, we need to take a very hard look at their responsibilities regarding doing annual surveys and that type of work, because I think that would be impossible. And I'd be happy to stand for questions at the appropriate time, or if you have questions that you want to pass along to me later on, I can get those answered for the committee as well.
Thank you. And committee, we do have all the conferees' contact information. If we do not have time, you may contact them by email, text, or by phone call. I would direct that we have one written neutral, Ken Titus with the Kansas Department of Agriculture. He's on WebEx for questions only. His contact information is in his testimony, so if you need to contact him. We're running a little short of time. So with that, anyone else appearing in person that wishes to offer any testimony? Seeing none, I will close the hearing on House Bill 2025. Committee, we've got about 2 minutes here. I will open it up for bill introductions, if there is bill introductions. If you'll note, there'll be a new agenda out today. We're going to add a few things for next week. We got to sign some bills yesterday. And I'm also going to have a briefing by the lottery director. I think you need to have a basis of knowledge how the lottery works. I'm hopeful to also get Debbie Beavers in with the Alcohol Control Board. She's the director. So expect that probably next week. Anything else for the good of the committee? Now, we're not meeting tomorrow. Yes, Representative Miller.
I just wanted to update you. In the last 24 hours, I have not been able to contact any dirty girls.
I won't say anything. I have a very good comeback, but I'll catch you a little later. With that, folks, if there's nothing else, no meeting tomorrow, no meeting Monday. There may be some bad weather for some of the folks that live out in western Kansas, maybe southeast Kansas. Hopefully not. It is going to be quite cold. I think the high on Sunday or Saturday is 17 and the low is 1. So get your coveralls out. With that, we are adjourned. Thank you.